most prosperous states of India in the south, Karnataka and Tamil Nadu. They have been fighting over a river called as Cauvery for almost 130 years. Recently, Tamil Nadu asked Karnataka to release a certain amount of water from Cauvery River for the drought-hit farmers in the state. Karnataka, on the other hand, stated that it is suffering from the monsoon deficit. There is 32% deficiency in rainfall this year, and this it cannot basically transfer the water to the state of Tamil Nadu. That shows that the flashpoint dispute conflict to some extent still is alive. In this video, we are going to discuss, analyze the entire story of Cauvery Water Dispute, starting from the history and then talking about the legal challenges and how judiciary has stepped in, how Supreme Court has stepped in every time whenever these two states had dispute related to the sharing of water from this river. Now, interestingly though, the dispute is largely between the states of Tamil Nadu and Karnataka. Cauvery River basin is shared by two other states. A small part of the basin lies in the Kerala, especially the western part, and the easternmost part is flowing to the region of Puducherry, specifically Karaikal region. So, any changes in the water sharing over the river Cauvery is going to influence the water rights of all these four territories of India. So, let us try to understand, and starting with that what this entire dispute all about, why these two states are fighting over the river water. Now, the river itself is very small river. The total length of river is about 800 kilometers and the dispute is about 130 years. The origin of this dispute can be traced back to as far as 1892. That is the British India, when the Karnataka was referred as the state of Mysore and Tamil Nadu was Madras Presidency administered by the British authorities. 50 million plus people currently live in the Cauvery basin, and that's why the dispute directly influences the life of these people, whether it is the farming community or whether it is for the drinking water purposes. As we have discussed, four states and Union Territory share one small river. So, in June 2026, a recent flashpoint was seen as far as this dispute is concerned, because Tamil Nadu demanded that emergency water should be released for the drought-hit farmers. Karnataka, as we have discussed, said that it is unable to do so because of the deficiency of the monsoon. Now, southern rivers, you will see disputes are more frequent and common. It is because they are largely dependent upon the monsoon rainfall. They are monsoon-fed river to some extent. And compared to the northern plains of India, when the river Ganga river system, Indus river system, Brahmaputra river system, you look, the dispute is relatively less frequent and less common because they are perennial river getting water all the time through the melting of glaciers in the Himalayas. Now, in this context, as far as the river Cauvery is concerned, the core question that arises is that when a river is passing through several different states and union territories, who owns the water of a river? The state where the river originates, where it begins, or the states that depend on it downstream? And this is the question that Supreme Court has tried to answer, governments have tried to answer in the past as well. Now, before understanding the dispute, let us try to understand the entire Cauvery basin. So, the river originates from a region called as Talkaveri, located somewhere about 1276 meter in the Kurg region of Karnataka, that is the Western Ghats mountain range of India, and then flowing in the eastward direction, it passes across the Karnataka plateau, then it flows in the state of Tamil Nadu through the plain, and then through the Tanjavur region and Pumpuhar region, it further flows out in the Bay of Bengal. The length of river is 800 km and it is joined by several important tributaries. The major tributaries of the river is Harangi river, you have Hemavati river, then Kabini river, Bhavani river, Amravati, Noyal and Lok Pavani. Cauvery river also has several structures on itself, the most important one being the Krishnaraj Sagar Dam, KRS Dam, that is used to generate hydroelectricity as well as it supplies water to the Bangalore region as well. Apart from that, Kabini river itself is important tributary. Further south you have Mettur. Mettur dam is very critical for the Tamil Nadu as the hydroelectricity generation. Apart from that, the farmers who grow rice crop in the monsoon season are largely dependent upon the flow of water from this Mettur dam as such. And then further if you go south from Tiruchirappalli region of Tamil Nadu, river forms a kind of delta-like structure, and after that through the Kalanai dam, which is also referred as Grand Anicut, The water then flows out near the Pumpuhar, which is ancient port town, and then enters the Bay of Bengal. So the dispute that we are talking about refers to the dispute of this entire basin area. In the west, if you look, because Karnataka has a border with Kerala, a part of the Kerala also is dependent upon the Cauvery River system, and then in the south, along the coast of Tamil Nadu, you will find the Union Territory of Puducherry. That's why 4 different parties. Now the question is that how did the dispute begin? And this we can trace back to the year 1892. Agreement was reached between the state of Madras and the Mysore kingdom. In this agreement, it was decided that for any project that Mysore state would build over the Cauvery River, whether it is the hydroelectricity project, whether it is the dam construction, whether it is the balancing reservoir construction, no matter what, even irrigation related infrastructure will require the consent of Madras. Only after the consent of Madras, Mysore state will progress to develop those structures on the river. Then next important development, major development occurred in 1924 when Mysore was allowed to build the Krishnaraj Sagar Dam. We just have seen the photograph, KRS Dam also called in the short, in the Ramnagara region of the Karnataka. And in this particular agreement, Mysore was allowed to build KRS Dam, but at the same time agreement capped the irrigation water that can be used by the state of Mysore. Now this agreement was signed in 1924 and it had its validity till 50 years. That means in 1974 this agreement lapsed. Now as the 1924 agreement lapsed, Karnataka said that now it is free to expand its irrigation capability unilaterally because now it is no longer bound by this 1924 agreement. Tamil Nadu on the other hand says that because of the 1924 agreement, a particular way of use of the Cauvery water is seen in the Karnataka and the Tamil Nadu. That's why Karnataka had to still follow the spirit of this agreement, even though agreement is legally not binding or legally not valid today. Then the dispute kept coming up every now and then when the dispute was referred to the parliament, Cauvery Water Dispute Tribunal was constituted in 1990, and finally in 2007, the Cauvery Water Dispute Tribunal, after studying the entire basin area, after investigating and looking into the demand, requirement and the need of Cauvery water for the both of basin states, it delivered its final award and then distributed the water among all the 4 regions of the Cauvery River. Now this particular award itself caused a lot of consternations as people of Karnataka and Tamil Nadu were not happy with it, right? So that's why what we are seeing is that in the late you have the anti-Tamil right in Bangalore that we see. Apart from that, we also see that in Tamil Nadu you have counter protests that began. So all this tell you how important is the river for both of the state. In 2018, Supreme Court intervenes and it then modifies the verdict, the final award that was given by the Cauvery Water Dispute Tribunal, and then also apart from modifying the award, Supreme Court set up CWMA and CWRC, Cauvery Water Management Authority and CWRC. About that we will discuss in the later slides, that what is the verdict of Supreme Court and what are the functions these organizations had to fulfill. Now 2026 flashpoint is also because of the region and decision of Karnataka to revive the Mekedatu balancing reservoir. Mekedatu is a gorge through which Cauvery River flows through before entering the Tamil Nadu plain. So that's where the government of Karnataka is planning to build a balancing reservoir that would basically will help in generating about 400 megawatts of hydroelectricity, and also it is expected that some water that earlier was flowing to Tamil Nadu, that water volume would reduce. That has opened the old wounds, and Tamil Nadu now has approached the Supreme Court again saying that such kind of project should not be allowed on river Cauvery unilaterally by the government of Karnataka. Now, if you try to understand first of all the legal architecture that governs the entire dispute, whether it is the Cauvery dispute or any dispute for that matter in the India, it is the entry 17 versus entry 56. That's where we can say is the legal problem and challenge line. Now, when you talk about the water, water is put in the state list. As you know that in the Constitution of India, we can understand that all the matters or basically all different subjects are classified into three lists. You have the union list, state list, and you have union list, you have a state list, and then concurrent list. So basically, if you look at this here, water is a state subject and a state list, but when we talk about the interstate rivers, they fall under the union list, and that's why Parliament has been given the power, regulatory power, that in the public interest it can regulate the flow of water and management of water. Then the other important constitutional article that governs the water dispute is Article 262. Now, under Article 262, the Parliament of India is empowered to provide for adjudication of interstate river dispute. It simply means that if two states, three states, or several other territories of India are having some confrontation that how to share the river water, who should have control over how much water, in that case, Parliament can step in, it can make the legislation, it can make the law, and interestingly, it can even bar the Supreme Court's jurisdiction over them as such. Then, under this power, Parliament of India has instituted an act that is called as Interstate River Water Disputes Act in 1956. This we have seen was enacted under Article 262, and it is this particular act that provides the mechanism for setting up tribunals, because remember we have discussed the award about how much water would be shared by both the states of Karnataka and Tamil Nadu was given by Cauvery Water Disputes Tribunal. Similarly, if any river you have like Krishna River Dispute Tribunal, you will find you have Godavari River Dispute Tribunal, Maharadi River Dispute Tribunal. So all of these tribunals that you have for different rivers are set under the Interstate River Water Dispute Act 1956, and this is constituted whenever a state or couple of states raises a dispute or confrontation arises. Now, Cauvery Water Dispute Tribunal was set up under the Interstate River Water Dispute Act, and then as we have seen, it delivered its final order in 2007. Now, obviously that order was modified by Supreme Court later. So, how Supreme Court modified it, what are the changes that have been made, we will discuss that. Before that, I would want to bring your attention to the fact that Legacy IAS Academy, we are going to soon commence regular batches, that is weekday batches, Monday to Friday on 3rd of August, 7th of September and 3rd of November, and similarly weekend batches are going to commence on 8th of August, 10th of October and 12th of December. Now, in this particular batch, we ensure that comprehensive coverage of GS paper right from GS1 to GS4 is done in the class, and also we ensure that even after class, if students are having difficulty in understanding some concepts or they do not know how to remain on track as far as the examination is concerned, one-to-one mentorship and doubt solving sessions are arranged as well. Now, regular interaction with educators is one important aspect which help student in ensuring that they understand the nitty-gritty of the examination, the demand of the UPSC examination as such, and that's why we also ensure it. Plus, to ensure that there is a good this we can say interaction between students and the teachers in the class, we have policy of maximum 40 students per batch. Daily mains and writing practice also will have the option to enroll in, because we know that preparation of UPSC requires an integrated approach, both prelims and mains, and to evaluate your performance, test series are also what we provide offer to. Now, we know that apart from general studies, optional play a very important role in determining whether you will make the list or what rank you will get. So, that's why we also are offering optional course program in the four most of the we can say favorite optional of students, such as psychology, PSIR, anthropology and sociology. It will the course will commence on 17th of August. If you want to know more detail about the course programs and feature, you can reach out to us. You can give a call to the number being displayed here, and also you can download our Legacy IAS app, which will help you definitely in your examination. Now, coming to the 2018 Supreme Court verdict, we have discussed before in 2007, Cauvery Water Dispute Tribunal gave its final order that was modified by Supreme Court. Now, Supreme Court was basically hearing the petition that was between the state of Tamil Nadu versus state of Karnataka in 2018, and while delivering its verdict, Supreme Court clarified that Cauvery River itself cannot be considered as the river of any particular state just because it originates from there or just because it is flowing over a large distance in some state. Cauvery is a national asset. National asset means no single state can claim exclusive ownership of river Cauvery. And that's why it revised the CWDT's final formula. And what was the main revision done? So, what was the water sharing agreement, water sharing directions of CWDT before? There we have seen the changes. So, Karnataka share was increased after the CWDT's order revision. Why? Because Karnataka put its petition that Bangalore is a growing city, it is growing at a rapid rate, more and more people are coming there, and that's why Bangalore's drinking water demand has continuously increased. In the Bangalore, did not have any major river as such, that's why the dependency is on the Cauvery River water. So, Supreme Court understood that yes, this is the basically genuine this concern. That's why Supreme Court said that okay, Karnataka share can be increased. At the same time, Supreme Court stated that Tamil Nadu, it is a plain area. You consider Karnataka has largely mountainous and plateau terrain, while Tamil Nadu has a plain area. So, because of this, Tamil Nadu also has a groundwater reservoir to some extent. Supreme Court took into consideration the estimates of Tamil Nadu's groundwater and then trimmed, that means cut down the share in Cauvery water as was given by CWDT. That means Karnataka's share was increased and Tamil Nadu's share was reduced by the recent order or the latest order. At the same time, it directed the central government, Supreme Court directed the central government that Cauvery management scheme should be implemented and should be given effect to. Now, apart from that, also Supreme Court then established two important bodies, an apex body called as Cauvery Water Management Authority. This body was largely tasked with fulfilling or executing or implementing the order that was given by Supreme Court in this particular verdict as such. And to assist Cauvery Water Management Authority, another body by the name of Cauvery Water Regulation Committee was set up, which was more of a technical body. It had to assist CWMA in performing its task, and this body will be primarily responsible for measuring the total water volume in different reservoirs across Cauvery River. It will measure these volumes on a daily basis, weekly basis as well, and based on those data, then it will be determined that how and when water would be transferred or shared between both the states. So both of these are very important bodies as far as the management of this dispute is concerned. Now, if you talk about this dispute, after 2018 verdict, to some extent we have seen the friction point or friction between both of the states has reduced significantly, but still there is an ongoing trend that we see. Whenever operational dispute related to CWMA, any operational dispute related to Cauvery River comes, it is pushed towards CWMA and CWRC, but whenever you have some major projects, major dispute, for example, Meghdadu project we are talking about right now, in that case, Supreme Court retains oversight when it is dealing with some larger legal question. So, the question here in the recent case is that whether the Meghdadu project that Karnataka has proposed over Cauvery, is it a legal project and what should be the legality of it, or how to determine the legality of it. So, that question would be largely dealt by the Supreme Court of India. Now, when we talk about the dispute, each of the parties here have their own position. Now, Karnataka, it is an upper riparian state. Upper riparian means it is the state through which Cauvery River flows first before going into Tamil Nadu. Plus the origin point of Cauvery also is Tal Cauvery in the Coorg district of Karnataka. So Karnataka maintains its position that it is heavily dependent on Cauvery River water, which it cannot share with other states, or it cannot increase the share of other state. Why? Because irrigation demand of Karnataka is met by the river, and most importantly, the metropolitan city Bangalore, which is growing at a rapid rate, population is increasing very rapidly. Its drinking water to large extent, drinking water supply large extent depend upon Cauvery. That's why Karnataka should have the control over this. At the same time, it also maintains that the fixed release to Tamil Nadu cannot be guaranteed every year. The reason is because there is no fixed flow of water through the Cauvery. Cauvery, as we have discussed, is an example of more of a seasonal, or we can call as monsoon dependent or rain fed river as such. So when the river is monsoon dependent, rain fed, you know that monsoon rainfall every year is not of the same or uniform quantity. Every year it fluctuates. So whenever you have deficit monsoon year, Karnataka says that we cannot guarantee that same amount of water can be released to the Tamil Nadu. Meghdadu has emerged as a drinking water project, necessary project for the drinking water purpose, as well as flood moderation project, and Karnataka defines its project by saying that it is not a sheer grab. Karnataka is not constructing the Meghdadu reservoir, balancing reservoir, because it want to grab more water from Cauvery. It simply want it because it want to fulfill the requirement of drinking water for its people, and also to moderate the flood as such, and obviously the hydroelectricity can be generated as in any project. Tamil Nadu on the other hand says that to a large extent the farming in the deltaic areas of Cauvery depend on the amount of water present in the river, and Kuruvai crop that is sown where we have the rice harvesting that is done in the month of July, August, September, to large extent that rice cropping is dependent upon the water available in Cauvery River. That's why also Tamil Nadu says that more water should be given to it. 1924 agreement, as you have seen, it collapsed in 1974, but Tamil Nadu still believe that the terms of this agreement should shape, and it has shaped the decades of settled water use pattern that should not be changed significantly just because the term and condition has lapsed. At the same time, because Tamil Nadu is in the lower channel of Cauvery, it is a lower riparian state, its consent is legally required for new project. Karnataka should not build any kind of infrastructure project without taking into consideration the demand and requirement of people of Tamil Nadu, and without building some political consensus with the Tamil Nadu state government. Now, Kerala has very small share, so it seeks protection of its limited catchment area right. It does not have as such dispute with Karnataka, but it also opposes any changes that could reduce its modest allocation. Puducherry to large extent is having agreement with Tamil Nadu because it is lying in the tail end of the Tamil Nadu Delta, Karaikal region of the Puducherry, and it is the most vulnerable to any shortfall if seen in the Cauvery River water. Generally, it aligns with Tamil Nadu's demand for the assured release as such. So, this is overall we can understand is the position of all the states. Now, when we talk about the 2026, Meghdadu has emerged as an unresolved and friction point. So, it is basically a project of 14,000 crore, that is estimated project cost. 67 TMC is the storage capacity of the reservoir that will be built here. Then 4 trillion metric cube, 400 megawatt, that is a proposed hydropower project on the Cauvery River. And Karnataka, it has recently submitted a revised detailed project report for the Central Water Commission. Now, you have to understand that though Meghdadu project is being talked about, it has not received final clearances from many organizations such as Central Water Commission, Ministry of Environment, Forest and Climate Change, or even Cauvery Water Management Authority as such. So, these institutions also have to come in and talk about it. Supreme Court at the same time has called legal challenges premature because the DPR is still under technical scrutiny. There is no surety that whether the DPR submitted by Karnataka would be passed or not. That's why Supreme Court says that we have to wait for that, then only we can talk about this particular problem. Tamil Nadu, however, has even opposed that there should not be any kind of even discussion as far as the Meghdadu project is concerned at the level of Cauvery Water Management Authority of the DPR, and has moved the Supreme Court repeatedly saying that Meghdadu project should not be allowed to take shape as such. So, that is where 2026 flashpoint, recent flashpoint we have seen. Plus, in February of this year also, Supreme Court directed to create a separate tribunal, again shared between two states, Tamil Nadu and Karnataka, that is called as Pennayyar River. So, it shows that how the pattern is spreading, how dispute in one river basin can easily spill over to the other river basins, as we can see in this case. Now, the question is that what mechanism exists to settle the dispute? So, first of all, institutional strengthening is required here. Good faith use of CWMA, CWRC as neutral technical bodies for real-time monitoring and shared data. Both of states should respect its judgment because it is a neutral body. It works on the principles of the technicalities, the realities and scientific this measurement and all. So, whatever decision it takes, it should be accepted by both states. Second is basin level cooperation is required because the river is passing through two major states and has shared water with two other territories. Joint reservoir operation protocols and shared telemetry across all four states can go a long way in building confidence about the sharing of river water. Plus, we know judiciary every time has stepped in. Supreme Court has a key oversight as far as the legal questions regarding the project in this river is concerned. Expert bodies for operational matter, it has reduced conflict since 2018. As we have seen in 2018, Supreme Court established CWMA and CWRC. Both of these bodies have to large extent reduced the friction. This recent friction is because of the Meghdadu project. Then permanent tribunal reform is also expected and required because many experts from the field of hydrology propose there should be a standing tribunal. This standing tribunal should be for all interstate dispute instead of ad hoc dispute by dispute tribunal. For example, we have discussed that you have Cauvery Water Dispute Tribunal, Krishna Water Dispute Tribunal, you have Mahanadi River Dispute Tribunal. So, instead of that, they propose that there should be a single standing tribunal that would handle all the cases of dispute. Then demand side management is required. For example, we have seen that states have given this justification in the favor of the project by stating that the irrigation demand of the state is dependent upon Cauvery River. So, what we can do is we can reduce these demand by shifting to drip or sprinkler irrigation or micro irrigation we can say it, so that the demand of the water would reduce. Crop diversification can be carried out because paddy, that is rice harvesting, we have seen the Cauvery crops that you have. These are kind of water guzzling crop, water intensive crop. They absorb and requires large volume water. If we are able to shift to crops which are example of dryland farming, millet cultivation, then also all the states can basically derive benefit from it, and also focus should be on the groundwater recharge reservoir, so that even in the deficit monsoon year, water requirement can be met by extracting water from inside the surface. But the most important, the dispute has always a political color. Many of the parties, opposition parties in both states have always claimed and has made the allegation that the state government of Karnataka, Tamil Nadu, they are too soft on each other. So, this kind of thing required that there should be a political consensus building rather than talking about electoral rhetoric and all that, which is often proposed but rarely achieved. There should be a political consensus building. People, government, institutions should come together and find a lasting solution. In the last, we can say a shared river. such as Cauvery needs a shared future. Any future project, whether it is Meghdatu or any project in the future, needs a negotiated consent-based framework. It cannot be simply should not be carried out by a single state based on its own requirement necessity. It also should build consensus with the state. A definite judicial ruling is required here that reconciles Karnataka's drinking water needs and at the same time Tamil Nadu's assured flow requirement as such. That's how we can ensure that the dispute can be resolved finally and ultimately. That's all for this particular video. I hope you understood the entire history and the legal framework regarding Cauvery water dispute. Soon we'll come with the other river water disputes in the next session. Thank you very much.